Good day to you all. My name is Oliver Mashuma, and I'm a student at Africa University, a law student at Africa University, and today I'll be presenting on oral evidence under the law of evidence. Okay, so oral evidence, this refers to the spoken testimony given by witnesses during a trial or hearing. It plays a crucial role in the legal system as it allows individuals to present their version of events, share their knowledge, and provide first-hand accounts of what they have witnessed. In the law of evidence, oral evidence is considered to be a primary source of information, and it is often given more weight than written or documentary evidence, as it allows for direct examination and cross-examination of witnesses. This process helps to assess the credibility and reliability of the evidence presented. Okay, so now we're going to move on to the types of oral evidence. And the first and most common type of evidence, of oral evidence, is the testimony of the witnesses, and which is also known as oral witness testimony. And this is delivered live and on oath and subjected to cross-examination in the presence of the jury. Well, in Zimbabwe we don't use juries, but yeah, this will be in the presence of the judge. And it is the paradigmatic form of evidence in the common law procedural tradition. And according to Section 249 of the Criminal Procedure and Evidence Act, it is unlawful to examine any person as a witness if they have not sworn an oath other than a person prescribed in Section 250 and 251 of the Criminal Procedure and Evidence Act. And basically, what it says is, in order for you to testify in court, you have to swear an oath. That's the only way your testimony can be admissible in a court of law. This greater emphasizes the requirement that the testimony of the witness has to be given under oath. The testimony of the witness can also be described as oral witnesses which are examined viva voice in court as to acts that are within their own knowledge and in some very particular and restricted instances what they have heard from another person, which amounts to what is called hearsay evidence in the legal profession. The rationale behind this practice of orality, having the witness testify in court, is such that the parties to the court proceedings not only have the opportunity to confront the opposing witnesses and cross-examine them, but also have the opportunity to scrutinize the demeanor of the witnesses, in order to ascertain their credibility. And in the case of State versus Adendorf, the relevant trial court had allowed evidence in chief of the appellant to be presented via the appellant reading a memorandum which violated the principle of orality. This procedure was criticized and described as being an entirely improper procedure which should not have been sanctioned. This improper procedure had also led to the issue that no cross-examination procedure was taken was taken in this case, which is a grave violation of the audi alteram partem principle, as all parties should have the right to be able to scrutinize opposing witnesses by way of cross-examination in order to test and ascertain their credibility. So, to those who might not know what audi alteram partem means, it basically means, as I just said, all parties should have the right to be able to scrutinize opposing witnesses by way of cross-examination in order to test and ascertain their credibility. Okay, and another type of oral evidence that can be admissible in a court of law is affidavits. Is an affidavit. Affidavits An affidavit is a sworn statement which is signed before a commissioner of oaths by a deponent, and the commissioner of oaths administers the oath to the deponent. So basically, a deponent is someone who's who's giving the affidavit, who's giving the information on the affidavit. That's what a deponent is. And it is easy to confuse these with documentary evidence, as an affidavit is a form of a document after all. However, even though the evidence within an affidavit is not presented viva voice, it is still considered to be a subset of oral evidence, as scholars describe it as being oral evidence which does not strictly conform with all the requirements needed for oral testimony with the main requirement that is not being met being the fact that the evidence is not presented viva voce as mentioned prior. Just like with oral testimonies of the witness, affidavits have to be exhibited under an oath or affirmation. The admissibility of affidavits in a court remains problematic, and one of the main reasons as to why that is because of the absence of a cross examination when evidence is exhibited to an affidavit. So, although affidavits may be efficient and convenient for the courts, their use and application is regulated in a stringent manner, and usually they can only be admissible in cases whereby there is no dispute of fact or is only allowed for uncontested or formal evidence. In Zimbabwe, this stringent application and admissibility of evidence exhibited by affidavits is prescribed by the Criminal Procedure and Evidence Act. This piece of legislation prescribes in section 278 a number of situations where affidavits may be admissible, and these are mostly all situations whereby only formal and uncontested evidence is required, and also situations whereby there is no dispute of fact. So, an example of what this might be is whereby they're giving what is called expert evidence. And expert evidence in a nutshell is basically evidence that is coming from an expert. So in a case, if you're trying to ascertain a medical fact, you get a doctor to come give his opinion. That's expert evidence. And these situations, no one can really object to this information being given by the doctor because they're not experts in the field. So in such situations, affidavits can be admissible because you're not really going to cross-examine a doctor based based on facts in the field of medicine when you're a lawyer and you're not an expert in that field. So yeah, that's one of the situations whereby affidavits are admissible without any issues. And earlier we talked about how affidavits are problematic, especially due to the absence of cross-examination. But the courts are said to have a discretion to call the witness responsible for the affidavit to come in to give oral testimony, which means that the opposing party can still challenge evidence that is exhibited by way of affidavit. And an important facet of affidavits that needs to be mentioned is the fact that there is some evidence within affidavits which is inadmissible in court, with the two main types being hearsay evidence and evidence that is excluded by inherent legislation. And in the case of Barron versus Barron, it is stipulated that generally affidavits must be confined to such facts as the witness is able of his own knowledge to prove, except in interlocutory motions and urgent applications where hearsay evidence may be admitted. So in general, hearsay evidence in affidavits is inadmissible. And now we'll move on to the last type of oral evidence I'll be talking about today, and that is interrogatories, interrogatories, whichever way you want to say it. And these are another type of oral evidence. And simply put, this is when parties draw up a list of specific questions that they would like to pose to a witness that is not present. This is provided for by the Criminal Procedure and Evidence Act in section 241, which states that any party to any criminal proceedings in which a commission is issued may transmit interrogatories to the judge or magistrate directing the commission. Although this section pertains to evidence on commission, which is a whole other topic, it can also be used it can also be used when it comes to interrogatories, as it is said that interrogatories are similar to commissions in both procedure and the principles underlying the application. This is said in the Criminal Procedure and Evidence Act. So yeah, you can use the same principles for evidence on commission. You can use those same principles when it comes to interrogatories on their own as a type of oral evidence. And the courts are allowed to add their own questions as well in order to ascertain the credibility of the witness. These questions are sent to a court in the jurisdiction of the witness where the somewhat, you can call it cross-examination, it is cross-examination, where the somewhat cross-examination of the witness is conducted by the way of the court summoning the witness and putting the questions to the witness whilst the answers are being recorded. This record is sent to the initial court from whence the interrogatories were issued and is presented in court during trial as part of admissible evidence. Section 278 of the Criminal Procedure and Evidence Act provides for the use of interrogatories in Zimbabwean courts in situations whereby the courts find that it is necessary for a person who made an affidavit to give oral evidence in relation to information contained in the affidavit, and that may be done through the use of interrogatories. And this section also stipulates that the mere production of interrogatories in court proceedings shall be admissible in evidence. Okay, and now we'll briefly talk about the purpose of oral evidence. And yeah, basically, the purpose of oral evidence is to enable the court or tribunal to hear directly from the witnesses themselves. This allows for a better understanding of the facts and circumstances surrounding a case. It also provides an opportunity for the parties involved to challenge or question the evidence presented. Okay, so the main topic here when it comes to the purpose of oral evidence is to allow for cross examination. And in order to address this, I shall talk about the examination of witnesses in general, how witnesses are examined in a court of law. And with examination, there's four stages of examination, and you've got examination in chief, and this is what happens first, and whether this is whereby the examination in chief, and the purpose of the examination in chief is to present evidence that aids the case of the party which is calling the witness. And with this one, two main methods can be used during this process, which are question and answer style of examination, or the method whereby the witness is allowed to tell their story with minimal interruption. And and during this type of examination, leading questions are generally prohibited because as an attorney or a prosecutor, you can't ask questions that kind of give away the answer or that push the witness in the direction in which you want them to go. You have to let them be able to tell their own story for them to be a credible witness. Okay. And after examination in chief, you've got cross examination. And this is one of the most important supplementary issues to oral evidence, as cross examination is viewed as being one of the key elements of the adversarial trial, where emphasis is placed on orality. It helps to ascertain the credibility of a witness and the strength and admissibility of their testimony. Cross examination as a procedure is actually part of the rationale behind the principle of orality, as alluded to earlier, which highlights its importance. And cross-examination is viewed as a fundamental and procedural right, and the case of S. of State versus Mgudu supports this notion, as it states that there can be no fair trial without the exercise of the right to cross-examine witnesses brought forward by the opposing party. And in a nutshell, cross-examination is simply just the questioning of the opposing party's witnesses, with the main goal of it being to discredit their testimony whilst eliciting information that aids the case of the cross-examiner. And after cross-examination, the next stage is re-examination, and a witness may be re-examined by the prosecutor following cross-examination in order for the witness to defend his responses to the questions posed to him during cross-examination. Re-examination inquiries must therefore be limited to issues raised during cross-examination and nothing else. After the other side has finished their cross-examination, a party may re-examine their own witness. This is done in accordance with the rules of evidence. Re-examination is a crucial step in the trial process because it gives the party the chance to elaborate on or clarify topics and address any problems that might have come up during cross-examination. The goal of re-examination is to get the witness to provide additional testimony that might have been missed or misunderstood during cross-examination. Any discrepancies, inconsistencies, or questions that may have surfaced during the initial interview may be addressed by the party conducting the re-examination using questions. Okay, and now we'll move on to the admissibility of oral evidence. And the rules of evidence, which are largely established in the Criminal Procedure and Evidence Act, govern the admissibility of all testimony in Zimbabwe, well, all evidence in Zimbabwe. These regulations offer standards and concepts that govern whether oral evidence is admissible in court cases. The admissibility of oral evidence is highly influenced by relevance. The rules of evidence state that evidence is relevant if it tends to prove or refute the fact at issue. The court will determine whether oral evidence is pertinent to the issue at hand, and can help prove the veracity or falsity of the claimed facts. Another crucial factor in determining whether oral evidence can be admitted is the credibility of the witnesses. The weight that should be given to witnesses' oral evidence will be decided by the court after considering the witnesses' demeanor, character, and credibility, consistency, manner, and any potential biases or motivations that can undermine the witness's credibility may all be taken into account during this evaluation. This issue of the credibility of witnesses shall be expanded on later. Okay. And a key tenet governing the admissibility of spoken evidence is the hearsay rule. Hearsay evidence is testimony based on what a witness overheard others say, rather than what the witness saw, heard, or otherwise observed. As a general rule, hearsay evidence cannot be used to establish the veracity of statements. This is because the real observer is not providing the evidence, making it impossible to cross-examine him or to determine whether his testimony is credible. Additionally, there is a chance that a second-hand account of what the original observer stated will be wrong. The hearsay rule, which generally applies in Zimbabwe, says that any testimony presented by a party who is not present in court to support an assertion of facts is inadmissible. However, there are acknowledged exceptions to this norm, such as dying declarations and statements made in the course of duty. If the hearsay testimony satisfies certain legal requirements, it may be admitted under certain exceptions. Okay, so just to recap on the admissibility of oral evidence, not all oral evidence is admissible in court, and there are certain rules and requirements that must be met for oral evidence to be considered admissible, and we've just gone over these. And these rules vary depending on the jurisdiction and the nature of the case. It is important for legal professionals to be familiar with these rules to ensure the proper presentation and acceptance of oral evidence. And in the case of Zimbabwe and its jurisdiction, we've just gone over the rules that are found in the Criminal Procedure and Evidence Act. And now we move on to the importance of oral evidence, and we'll just touch briefly on this. But oral evidence holds great importance in the legal system as it allows for the human element to be brought into the courtroom. It gives witnesses the opportunity to share their personal experiences and perspectives, which can greatly influence the outcome of a case. It also allows for the examination of witnesses' demeanor, body, language, and overall credibility. So basically, it allows for cross-examination, which is a very key tenet of all evidence in general. Because if you're going to have people speak in person, viva voice, as we call it, then you must be able to ask them questions in order to ascertain their credibility and to in order to make sure that their testimony is true. Because you can't be convicting people on the basis of false testimonies. So, in conclusion, all evidence is indispensable within the law of evidence, and even though it presents its own challenges, such as reliability, its own challenges such as reliability, these challenges can be overcome by concepts such as cross-examination, which are there to challenge the reliability of the oral evidence that is being presented. So great emphasis again is put on cross-examination, on cross-examination. Okay, so oral evidence, while indispensable within the law of evidence, presents a complex array of challenges. Its reliability can be influenced by numerous factors, necessitating careful scrutiny and evaluation. This is the main reason why great emphasis has to be put on topics of the admissibility of all evidence, as well as evaluation of witnesses. This is because, due to the unreliable nature of oral evidence, there has to be statutory guidelines, among other guidelines, such as common law guidelines and juristic precedents, that dictate how and when it's applied, and also that dictate the amount of weight it can hold in a court of law in order to prevent, as much as possible, the miscarriage of justice. Thank you.